Good morning. We'll call our meeting to order. It's 9 o'clock on that clock and about 9:02 on my clock, but we'll go to the clock on the wall and start out. We'd like to call the meeting to order, and we have final action that we're going to do on three different bills today. So have enough to do that here, and if we have I think we have at least one online, Representative Toplicker, and if he's in the building, he'll be able to vote on this. Oh, okay, Representative Neely, and looks like you're in your office. So you're good. And we'd like to start out with Senate Bill 337, which is converting the conditional charter issued for the pilot program under the Technology-Enabled Fiduciary Financial Institution Act to a full fiduciary financial institution charter at December 31st, 2021. So may have stolen David's thunder there, but David, could you give us a brief review of Senate Bill 337?
Thank you, Mr. Chairman. I think you covered it pretty well. Yes, this is the bill that converts that conditional charter under the pilot program to a full fiduciary financial institution charter, retroactive back to December 31st, 2021. Just clarifies what came out of the Joint Committee on Fiduciary Financial Institutions oversight as part of the recommendations from that committee to have that date be clear in the statute. So.
Any questions for David? If not, committee, what is your pleasure on Senate Bill 337? Representative Anderson?
I move to pass Senate Bill 337.
Okay, move it to pass it out of committee. Is there a second? Representative Lynn. I have a motion and a second to pass out Senate Bill 337. Any discussion? No. Okay. Any proposed amendments? None? Oh, so we do have a motion and a second then to pass it out of committee. All those in favor signify by saying aye. Opposed, nay. Motion passes, and Senate Bill 337 is passed out as it was presented to the committee. Our next bill that we have final action on is House Bill 2489, and I'll just let David do that one, and I won't say anything, David.
Thank you, Mr. Chairman. Yes, House Bill 2489. This was an amendment requested a bill requested by the Office of the State Bank Commissioner as part of the agency's required report and recommended legislation under the TEFI Act. This bill would make several amendments to the TEFI Act. There would be a new section for critical undercapitalized or insolvent TEFIs and the procedures on when those events occur. There's amendments to the definition of FIDFIN. There's additional criteria for when the State Banking Board may deny a TEFI charter application. It amends language really regarding the TEFI initial fee. There's also then language about assessment statements from the commissioner when those shall be sent and in the manner that they should be sent, and allows for installment periods for payment of any assessments. There's also a definition of insolvent that captures the current definition in the state banking code for banks and trust companies. It would add language giving the commissioner discretion to require a TEFI maintain bonds and insurance policies. And it would also amend language relating to the examination of TEFIs. The commissioner would not evaluate the safety and soundness of a TEFI, but the commissioner would evaluate profitability, compliance with state and federal laws, and the TEFI's IT systems, policies, and practice. And then it also amends powers of the TEFI to engage in trust business by requiring such trust business be incidental to engaging in FinFin transactions. The bill adds language for when a TEFI can extend financing, such as through loans or direct investments. Requires the commissioner to adopt rules and regulations that enumerate categories of FinFin transactions. Those rules and regs would specify the concentration limits for each category based on category's risk profile. And it requires the TEFI to disclose to the customer information required by rules and regulations of the commissioner to ensure that the customer is informed regarding the nature of the transaction. Requires the TEFI to provide prompt written notice to the commissioner when engaging party to provide services or when a trust advisor is appointed. And adds language when a TEFI by contract or otherwise causes any service authorized by the TEFI Act to be performed by the TEFI and the performance shall be subject to regulation and examination by the commissioner to the same extent. And then adds some language concerning the end of the pilot program, which kind of has been taken care of with 337, but it does have that language in there at this point. And then finally, the bill amends KSA 39-1401 to add fiduciary financial institution to the definition of financial institution, to make a TEFI a mandatory reporter of any instances of elder abuse, as is required under current law for other financial institutions.
Well, David, I'm glad I let you do that, and I didn't say anything. Are there any questions for David on House Bill 2489? Thanks, David. So we'll now take up House Bill 2489, and is there a motion concerning this bill? Have a motion from Representative Poheisel.
Thank you, Mr. Chair. I move that we pass out HB 2489 favorably.
Is there a second? Representative Shu seconds. We have our motion. Is there have a motion and a second? Are there any proposed amendments to House Bill 2489? Representative Poheisel.
Thank you, Mr. Chair. I do have an amendment.
As after they get passed out, we'll have you explain your amendment.
Absolutely. So you guys remember last year when we did the TEFI, the trust fund bill, we also put a provision in there establishing an oversight interim committee. That committee met, I believe it was December 7th. Chairman and I served on it. The ranking member was on vacation at the time, so he couldn't be there. One of the recommendations that the banking commissioner brought was the proposed legislation before us today, and it was our recommendation to file that into our committee at the start of this year. And in the meantime, we urge the banking commissioner and Beneficient to get together to work out any differences so we could have some compromise language and we don't have any unintended consequences of the proposal that the banking commissioner had. I'm pleased to say that they both got together and worked out their differences, and the product that you guys see before you in this amendment is the compromise language between the OSBC and Beneficient. The changes that are made from the original bill to the amendment, a lot of them that are put off have been agreed to be put off until after an examination is performed. As far as I know, and Mr. Chairman, you can back me up on this, this is an agreement that both sides are happy with and acceptable with. With that, I'll stand for any questions or if David would like to explain the amendment any further.
Pardon? First, I was thinking we did have, but was there a second on the amendment? Representative Anderson. Go ahead.
Thank you, Mr. Chairman. Yes, as Representative Poheisel indicated, this was sort of a compromise language that's come out of between Beneficient and the bank commissioner's office. It's actually shortening the bill quite a bit. If you see Section 1, that new section related to the examination for undercapitalized or insolvency, that is coming out, so that will be completely removed from the bill. And it also then just cleans up in the very beginning of Section 2 on page 2. We don't need that Section 1 reference, as that's coming out of the bill. Then on page 3, it just kind of goes back into that definition of FIDFIN services, and it allows it to be instead of an or, instead of an and, it's now an or both, and inserts back in that language, including loans, extensions of credit, direct investments. Page 6, in subsection D down there, starting in line 22, those amendments are being removed, so we would just revert back to current law as it exists now in subsection D. It'll just be those two conditions for denying an application. And then it does address the fingerprinting situation that came up with the FBI in subsection F at the bottom of page 6. It would strike the language or any other person related to the application, since it was indicated as a problem with the FBI background checks. So it would just be an officer, director, or organizer of the proposed financial institution would be fingerprinted. Page 8, section 4 down there in lines 30 through 32. This is on the non-refundable fee. It would be until July 1, 2025, the application fee would be $250,000, and then on and after July 1 of 2025, the application fee would drop to $100,000, so it would not be a $500,000 fee anymore. Then at the bottom of page 9 and following on, we're just actually removing sections 5 and 6 from the bill. Those amendments had been pulled out, so there's no need to have those sections in the bill anymore, since they will not be amended. And then on page 12, down in line 35, we're striking the amendment not evaluate safety and soundness. All that safety and soundness language will be removed from the bill. And then you'll see that kind of more over. So in page 13, and this is part of the examination situation, profitability now would be, shall not be a consideration in evaluating a fiduciary financial institution. And then we bring back in that exist in the business, that's current law, so that just stay. And then the subsection D that was proposed is being stricken in lines 26 through 31 on page 13. On page 14, it's now line 5, extend financing such as through loans or extensions of credit, and strikes the direct investments amendment. And then in lines 13 through 15 on page 14, that's being stricken as well. So it just stay really as current law in that subparagraph C. Page 16, this was on the rules and regulations relating to asset categories. That language is being stricken, but it does keep the disclosure to the customer with an additional piece of language that says taking into account the level of sophistication of the customer. Page 17 strikes prompt written, as that's sort of a bit maybe vague or unclear there. Page 18, again, strikes that promptly, and just says within 30 days of the establishment of such capacity, they would have to notify the commissioner in writing. And then section 14, this was about the pilot program and terminating the pilot program. That's being removed now, as I said, with kind of with Senate Bill 337 moving through, kind of taking care of that. There's no need for that section to remain in the bill. And then the last thing is just really just cleaning up the title in the repealer to reflect that those certain sections that don't need to be in the bill anymore are being removed, so as they do no longer have any amendments to them. And I'd be happy to stand for any questions.
Questions for David? No questions? Weigel, you have a question?
Yes, I do. Thank you, Mr. Chairman. David, you went over a lot of this, and I was trying to keep up reading with it. Does the state banking commissioner, state banking office, do they sign off on all of these changes as far as what, like it says, let me find it here. Well, on the last one, I was looking ahead, and you're talking about it on page 17. Fiduciary financial shall provide, and then prompt written is stricken. So what exactly does that mean? That they don't have to, in a timely fashion, notify the state banking officers or the commission, or is it that they don't have to notify them in writing? Exactly what does that mean?
Mr. Chairman, yes, that language is being stricken. I believe the bank commissioner's office and beneficent have agreed to this language. That's my understanding. Yes, I think the idea of prompt is maybe just a bit unclear. I mean, I think they are required to still provide that notice. And like I said, as you go over to page 18, it's within 30 days. Instead of just using the term promptly, that was maybe a bit vague or unclear. It would be that notice. So.
Okay, so it's within 30 days, correct? The way I'm reading that?
Yes.
All right. Okay, thank you. Thank you, David. Thank you, Mr. Chairman.
Any other questions? Representative Shu?
Thank you, Mr. Chair. I don't have any problem with the amendment, really, especially if it's been agreed upon by both sides. A clarifying question for Representative Hoheisel for something he said. So some of the sections that have been stricken out, the understanding is we'll do an examination first and kind of see how that goes, and then maybe see if they end up being necessary.
Correct. That's my understanding is after the examination is completed, that they'll come back and we'll review these further.
Okay. Thank you.
Representative Osman?
Thank you, Mr. Chair. Page 13, I'm looking at section 8, subsection D. I'm not sure what the full breakdown is. That entire thing is crossed out. It reads to me as if this is oversight on that is being struck from here. Can you tell me what the nature of this particular section is? And then perhaps for Representative Hoheisel, why this was struck out?
David, if you could.
I can't really speak to why, except as part of the agreement, but I will say, yes, that subsection D it would just be that the commissioner would be able to examine an aspect of the TEFI, regardless of whether or not it's within an enumerated reason within the section to help aid in the understanding of the fiduciary financial institution's business operations or effects on Kansas, or to help guide rules and regulations or any proposed legislative changes. I think it was just, since, this is a newer entity of financial in Kansas, I think they just wanted to get some more understanding. But yes, I believe that they will actually want to have like the examination maybe before putting that in. But I might let Representative Hoheisel speak to the purpose.
Yeah, I think David kind of explained it. That's probably some language we'll review after the examination is complete. Like I said, and we have members of the Banking Commission back there as well, shaking their head in agreement that we've all signed off on this. So.
That answer your question, Representative Osman?
Thank you. I suppose, I understand that everybody signed off on this. I'm just trying to figure out, does this remove full oversight, or is this just a limited time? You're explaining that it's a limited time period. I'm just trying to understand what is the oversight then, and how much of it has been removed based upon this subsection.
Representative Hoheisel? We might ask Matt if you would like to come up and make a comment on that. It might lead more to, since you and Beneficient were involved in the compromise.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, my name is Matt Shoger. I'm a staff attorney with the Office of the State Bank Commissioner. That subsection there is not currently in the TEFI Act, so the bill was going to add it. We decided to strike that to look at, after a first examination, what kind of things we might want to be able to see more of, like what kind of things did we not see that we might want to. We might be able to tailor that language a little more specifically based on our experience with the exam. No problem.
Thank you, Matt. And Mr. Fletcher, would you like to, since it was a compromise, would like to just kind of confirm from your end?
Thank you, Mr. Chairman. Yes, I think from our end, it was really the terminology examine versus review, certainly different standards. So the concept was, after an examination, then in conjunction with the OSBC, to determine what areas need to be examined, which is certainly a higher standard, what areas might want to be simply reviewed in terms of the educational process to gain further insight into the nature of a TEFI's business. So once we conclude the examination, we'll have more insight into that distinction and what areas should be subject to examination versus review. Thank you, Mr. Chair.
Thank you, Derek. Any other questions for the maker of the motion, Representative Hoheisel, or for our reviser, David? Okay. There are no other questions on the amendment. Representative Hoheisel, would you like to close on your amendment?
Thank you, Mr. Chair. And real quick, I would like to thank both the Office of Banking Commissioner and the folks at Beneficient for bargaining and negotiating in good faith on this. I think this is a good step forward. We still have our oversight committee established in last year's legislation, so we can look at anything this summer or fall and review and come back next year with further legislation. And with that, Mr. Chair, I close on my amendment.
Okay. On the amendment by Representative Hoheisel, all of those in favor signify by saying aye. Aye. Opposed, nay. Motion passes on the amendment. We're back on the bill. Is there any other amendments to be offered on our bill 2489? Representative Wassinger?
Thank you, Mr. Chairman. I'm not sure. I see all different places where they refer to developing rules and regulations, and they've kind of made them very specific for the bank commissioner. What I would like to add into when the bank commissioner develops rules and regulations, that it is subject to, cannot go beyond legislative intent. And I have better verbiage coming, but I am concerned that we have no input whatsoever, having no power in joint rules and regulations to control any one of the departments or agencies within the state, whether you're a Democrat or Republican. If someone does something and puts something in that changes law and changes something fundamentally, we need to be able to say, no, you can't do that, and not have to bring everything up for statute. So maybe David can help me with that. If not, I can probably amend it on the floor when I have better. Yeah. Or rules and regs.
So just to clear with the committee, currently looking at page 16, lines, section 10, lines 14 through 18 is I believe what the maker of the amendment is referring to there.
Yes, I apologize. Thank you. I withdraw my amendment.
Thank you, Representative Wassinger. We are back on the bill. Are there any other amendments to our House Bill 2489? If not, Representative Hoheisel, would you like to close on this bill 2489?
Yes, sir, Mr. Chair. Thank you. I move that the committee pass out HB 2489 as amended.
We have the request to pass out 2489 as amended. All those in favor signify by saying aye. Aye. I need a second. Representative Anderson. Okay, we have a motion and a second to pass out 2489 as amended. All those in favor signify by saying aye. Aye. Opposed, nay. 2489 passes out of the committee. Okay, we have one more today, and it is House Bill 2568, and it's the Mortgage Business Act. And David, would you like to give us a review of the Mortgage Business Act?
Thank you, Mr. Chairman. Yes, 2568, this is amendments to the Kansas Mortgage Business Act. Kind of the primary amendments here are to allow certain mortgage business to be conducted remotely. So there's some definitional changes to application and bona fide office. Now it adds a definition of remote location and changes the definition of branch office, mortgage company, and principal place of business. Section 2 is kind of the, I guess, sort of the peanut of the bill, allowing mortgage business to be conducted at a remote location if they have the mortgage company's employees or contractors do not meet with the public at a personal residence. They do not keep any physical business records at that location. They have written policies and procedures for working remotely. That the company maintains computer systems and customer information in accordance with a company's IT security plan and all applicable state and federal laws. And then and if any device used to engage in mortgage business has appropriate security, encryption, and device management controls to ensure security and confidentiality of customer information. And then if the company's employees or contractors take reasonable precautions to protect confidential information according to state and federal laws. And then the company has to have an annual review and certify that their employees and contractors meet the requirements of the section. And upon a request of the bank commissioner, they have to provide written documentation of their review. Section 3 amends KSA 9-2204 and removes the requirement that a mortgage company submit separate applications for the company's principal place of business and each branch office, and instead just has only requires a mortgage company to only have to submit one application each time. Section 4 amends KSA 2205. This is the license and registration expiration, renewal and reinstatement requirements and dates. The bill provides that each license and registration will expire December 31 of each year, and a license can be renewed by filing with the commissioner a complete renewal application and a non-refundable renewal fee by December 1st of each year. Applications received after December 1st or that are incomplete as of that date would be assessed a late fee or may be assessed a late fee. And expired, a license may be reinstated through the last day of February by filing a reinstatement application and paying any appropriate application and late fees. And the commissioner may designate such late fees for consumer education and may allow them to be expended for consumer education purposes as directed by the bank commissioner. Section 5 amends KSA 2209-2208 and removes the requirement that each licensed location make available evidence of licensure to the consumers and general public. And then Section 6 would amend the surety bond requirement. Now would be a $100,000 surety bond filed with the commissioner for all companies instead of the current $50,000 for licensees who maintain a bona fide office and $100,000 for those who do not maintain a bona fide office, as that bona fide office requirement is being changed. So this is a $100,000 bond for all mortgage offices. The section also requires applicants or licensees to submit evidence that they are solvent and shall at all times maintain a positive net worth. And this deletes a current requirement that evidence of net worth be accompanied by a written statement by an independent CPA that the balance sheet or financial statement has been reviewed in accordance with generally accepted accounting principles. And then finally, Section 7 requires a licensee to provide written notice to the commissioner when the mortgage company is adding or closing a branch office.
Thank you, David. Any questions for David? No, well, this bill, like our previous bill, is a compromise bill. And again, on our previous bill, I appreciate the work that was done to compromise and come out with something we could deal with today. And the same way with the Mortgage Business Act. It's been one that was worked on by the Commissioner's Office and those involved. And so for 2568, is there a motion on 2568? Representative Hoheisel.
Thank you, Mr. Chair. I move that we pass out HB 2568 favorably.
Is there a second for 25? Representative Shue. We have a motion and a second. All those in favor signify by saying aye. Opposed, nay. Okay, we'll go into discussion on 2569. Any discussion on 2569 or any amendments to 2569? It's fairly quiet in here. It looks like no discussion, no amendments. The questions, there were no questions on it. So if there isn't, Representative Hoheisel, would you like to close on your motion?
Thank you, Mr. Chair. And again, I'd like to thank the Office of Banking Commissioner for negotiating this and working out the differences. And with that, I close.
Okay, is there a second? Representative Shue, seconds. Okay, we have a motion and a second to pass out House Bill 2568 favorably. All of those in favor signify by saying aye. All those opposed, nay. Again, all ayes. So House Bill 2568 is passed out favorably. Next week, we'll meet on Monday, and we have a number of bills. I think some of them will maybe be assigned to us today, but we had several that were introduced late that I think one has come in assigned, one has maybe been transferred to us, and we have some others in the process. So we'll determine on Monday, but we've got 3 meetings left. So the 3 meetings, we will try to have all the hearings on the bills that come in to us. We'll try to deal with those next week, and then also work what we can next week. And if we don't get them all, then we will do that on the following Monday. When we will deal with that. So we could have maybe 4 or 5 more bills, just depending on what gets up or what's transferred to us. So next week, I think the meetings will be a little longer than today because we'll be trying to do a number of them that we've not really had. Some of these we're familiar with from last year. Some of these new ones will not, and some of them will fill more in the line of our rural development than they would banking. So that'll be something that we haven't had. We didn't have that many of those last year. So we will watch the agenda out for what is going to be on Monday's meeting, and then we will have that. And after we're finished today, I'd like to ask Representative Hoheisel and Representative Shue to stay, and we'll do a little planning session with our reviser and research for what we know that we can line up for next week, and that will help us. And actually the following Monday, what we can look at since we're running down to the end of the wire. So. Appreciate the work today, and if there's no other things for the good of the committee, we will stand adjourned.